Hello everyone, welcome to Academy of Civil Services. And throughout these video programs, we would like to give you some important current affair topics which are relevant to our prelims examinations. And you know that the last 1.5 years of the current affairs are relevant for the preparations. And we would like to help you throughout these video sessions, which some topic were discussed frequently in the news, and those topics were in the major discussions and that are related to our syllabus like economy, polity, geography, and history, and including the science and technology, ecology, environment. So those topics will be discussed throughout this video session. And please stay tuned with us, and we'll help you to assist your preparation better. Now, moving on to another topic, that is Citizenship Amendment Act of 2019. Because of the NPR, sometimes it came in the news. Then CAA was discussed a lot of time in the news. Citizenship Amendment Act 2019. That's why the fact with regard to citizenship is important. And again, I would tell you, you have a Lakshmikant in your module. There is a separate chapter on citizenship. So the citizenship which talk about citizenship getting by birth, by descent, by registration, by naturalization, and as well as incorporation of the territory into India, like we have acceded like Goa, Pondicherry to India, or integrated to India. So the incorporation of the territory also will be one of the provisions we have given citizenship. So like that, citizenship, the fact about citizenship is again an important module that is relevant for prelims. The Citizenship Amendment Act of 2019, which notified on December 12, 2019, and it came into force from January 10, 2020. And it's almost 2 years has passed, but it was in the news again. It seeks to amend the earlier Act of Citizenship Amendment Act of 1955. So there are a lot where amendments were made to this 1955 Act. This was the last amendment made by the Parliament. That was known as the Citizenship Amendment Act of 2019. It was in a way to give a citizenship, like we know that citizenship provisions in India, we are giving citizenship by birth, by descent, by registrations, by naturalization, as well as the incorporation of the territory to India. These things we have studied in your polity classes. So the objective of this amendment, the 2019 amendment, was to give Indian citizenship to those persecuted minorities in our neighbor countries, including Pakistan, Bangladesh, and Afghanistan. So the persecuted minorities like Hindu minority, Sikh minorities, Jain communities, Buddhist minorities, Parsis, and Christians, except Muslim. All these persecuted minorities in these countries, Pakistan, Bangladesh, and Afghanistan, majority Muslim countries, those minorities were persecuted or came to India will be given an Indian citizenship. To give Indian citizenship to these persecuted minorities, the government has amended the earlier Act of 1955 in 2019. That was known as the Citizenship Amendment Act of 2019. So the time which will be calculated and when the people will be added to or given the citizenship, it has given a time limit. That is, those persecuted communities, we have seen the Hindu community, Sikh, Jain, Buddhist, Parsi, and Christian community who came to India till December 31st, 2014, who are facing religious persecution in their respective countries like Pakistan and Bangladesh and Afghanistan, will not be treated as an illegal immigrant, but also as will be given an Indian citizenship through this Amendment Act. This was the main objective of the CAA Amendment Act 2019. This was criticized on the basis of like giving the citizenship, accepting one particular community, Muslim. It was the political debate in that time, and still it is a political debate because with regard to the communities, it is not added one particular community in giving the citizenship. That's why it was a political debate. That we can leave that the intention of this act was to give citizenship to those persecuted minorities in the neighboring countries of the Pakistan, Bangladesh, and as well as the Afghanistan. So Afghanistan is also our neighbor country, and all those persecuted minority came to India till December 31st, 2040 will be given Indian citizenship, and they have to prove themselves as well. So, but the act has given some exemption. That means the act will not be applicable to our 6th schedule. we discussed in the first module, first topic, that is 6th and 5th schedule. In the 6th schedule, deals with the scheduled tribal areas of the Tripura, Mizoram, Assam and Meghalaya. This state has a district councils. There's a tribal areas, like in Assam there is 4 autonomous district council is there, and similarly the Tripura, Mizoram also have 3 district council, these areas. So all these areas mentioned in this 6th schedule of Indian Constitution, this act will not be applicable because their traditional rights must be protected. So the act passed by the parliament will not be applicable to the district or the autonomous council mentioned under the 6th schedule of these states of Tripura, Mizoram, Assam and Meghalaya, as well as we have familiar with the inner line permit. Some of the state has an inner line notification. Whenever we want to go to the Arunachal, we have to apply for inner line permit, then only we will be allowed to come inside the state areas. So in inner line notified regions of this Bengal Eastern Front, mainly the Arunachal Pradesh, will also be outside act of this purviews. So this is all about the CAA 2019. This is not applicable to the certain areas which is mentioned under the 6th schedule of the Indian Constitution. Talking about Tripura, the district council, already in the previous current affair discussed about district councils. In Assam, we have 14 areas, district council, autonomous council region is there. In these areas, this act will not be applicable. In remaining Assam regions, it will be applicable. Whoever is came to India, especially the persecuted communities, they will be given citizenship if they came to India till December 31st of 2014. This was the major provisions of the 2019 Act. This is the fact we need to remember. Mainly the states, in the countries included in this, Pakistan, Bangladesh and Afghanistan, not all the neighbors. It's only included Pakistan, Bangladesh, Afghanistan, the majority Muslim, majority countries, and those persecuted minorities who came to India till December 31st, 2014, facing the religious persecution, will be given Indian citizenship, will not be considered as illegal immigrants. The earlier class we discussed about foreign tribunals. If anybody lost the citizenship, they can approach the foreign tribunal to prove themselves. Like that also we have discussed in the previous class. That also you have to revise in this context. The Citizenship Amendment Act of 2019 would be a probable questions. And moving on to the next topic, that is the Collegium System. I think we have asked the question with regard to the Collegium System, frequently coming in the news. It is a system which mainly related to the appointment and transfer of the judges of the Supreme Court as well as the High Court. That way the collegial system was in the news frequently. So again, an important module, important persecuted. So the collegial system, again, it was an important topic under in our polity syllabus. So it is a system mainly deals with appointment and transfer of Indian judges to the Supreme Court as well as to the High Court. The main fact we need to remember is that the collegium system is not evolved through an act of the parliament or by a provision of the constitutions. This system was evolved through a judicial or judgment of the Supreme Court or judicial intervention. Like the basic structure, we have studied about basic structure. Basic structure is neither mentioned by the constitution, not evolved by the constitution or by the act of the parliament. The basic structure was evolved through the judicial innovation or judicial intervention. Similarly, the collegium system also, like that basic structure, it is evolved through a judgment of the Supreme Court, mainly the judges case of 1981, 1993 and 1998. Through the judgment of the Supreme Court on these judges cases, the collegium system was evolved. That's why this question which was asked, I think it was asked in your prelim, this test series. Again, anyway, we can solve this question with reference to the collegium system. Which of the following statements are correct? This question, we can expect this kind of question, whether this system is evolved through the constitution or not. That kind of question we can expect. And after discussing some point, we'll give you the question. Again, we'll follow with this content. This concept of the collegium system was introduced by the Supreme Court in the second judges cases in 1993, which is called as collegium system. That means in order to appoint the judges to the Supreme Court and the High Court, there should be a system, which system will include the Chief Justice of India and another senior most judges. In 1993, second judges, which was said that there will be consultation with the CJI and also as the two senior most judges of the Supreme Court, which is an institutional opinion will be consulted, and the collegial system that was called for this institutional framework. And later in third judges cases of 1998, it has expanded the number of this institution to 5-member body. Like earlier, it just talked about the Chief Justice of the Supreme Court and the two senior most judges in second judges cases of 1993. But 1998, it has expanded the body into 5. Now, currently, the collegium system has 5-member body. It's comprising of the Chief Justice of India, that is the Supreme Court, the Chief Justice of India, and 4 of his senior most colleagues. That is what the collegium system of Supreme Court. Again, we know that the Supreme Court collegium is that there are 2 collegium system exist in India. One is for the appointment of the Supreme Court judges and another for the High Court judges. Here we can see the Supreme Court collegium is headed by the Chief Justice of India, which is comprises of the 4 other senior most judges, and High Court judges or High Court collegium system is headed by the Chief Justice of that concerned High Court and another 4 senior most judges. Now, currently, the collegium system comprises of the 5-member body. If in the case of Supreme Court, it will be headed by the CJI and 4 senior most judges. If it is the case of High Court, it will be headed or led by Chief Justice of that concerned High Court and 4 other senior most judges. So once this collegium systems as giving the recommendation to the president, that means we know that the judges of the Supreme Court and High Court are appointed by the President of India and they are removed by the President of India. That the fact we have studied, that the Supreme Court judges as well as the High Court judges, including the Chief Justice of the High Court, all of them were appointed by the President of India. So once the collegium system will have a list of names of the judges, they will recommend to the President of India for the approval. Sometimes the President can either accept or reject it. If it is reject, it will send back to the same collegium system. And again, the collegium system, if it is for the Supreme Court judges, then Supreme Court Chief Justice of India and the 4 senior most judges, again, they will sit on this recommendation. It is like confirmed that the same will be recommended and they are the final list will be again sent back to the President. Then the President has to, or the President or he or she will be bounded by that recommendation. That means President then does not have any choice for rejection. He just has to accept the recommendation that which second time the collegium was sent or which was given the list. So once first time if they send the recommendation, President can accept or reject. But if again it's coming back, the second time President is bound to accept the recommendation suggested by the collegium system. Like we have seen that Parliament Act. When the Parliament Act, if they pass, when it goes to the President, President can give again for the Parliament for the reconsideration. But if it is coming again, will not be possible. He has to give an assent for that bill. The same kind of provision, same kind of procedure we can see that when an appointment of the judges, if the collegium system in the first stage suggests to the President, President can either accept or reject. But in the case of second time, it's also suggesting the same name to the President. President does not have any other option and he is bound or she is bound to that recommendation and accept this. And there was a bill was passed by the Parliament in 2015 that was called as National Judicial Appointment Commission Bill. But this bill was like invalidated by the Supreme Court because Supreme Court has the power to judge on certain amendment of the bill when it is passed by the Parliament, which is constitutionally valid or not. And finally, the Supreme Court in 2015 declared that it will affect the independence of the judiciary, so that the bill is invalid, which should be avoidable. So it has declared that it is an ultra vires by the Supreme Court. So it has removed or invalidated the National Judicial Appointment Commission Bill. Now, India does not have any Judicial Appointment Commission for the appointment of judges. Currently, we follow a system called as Collegium System, which is not evolved by an act of the Parliament or by the provisions of the Constitution. It is evolved through the judgment of the Supreme Court. We have seen that first, second judges cases, third judges cases, it has expanded the member up to the Collegium System. In Supreme Court, we have seen that it is headed by the Chief Justice of India with the four senior most judges. They will appoint the judges Supreme Court and High Court Collegium. We have seen that it is headed by the Chief Justice and four senior most judges. In with regard to Chief Justice of High Court also will be recommended by the Supreme Court Collegium. For appointing the Chief Justice of the High Court, we have seen in this, we have studied in the polity, which will be recommended by the CJS, Chief Justice of India, is consulting with the Supreme Court Collegium. They will be dealing with, but other judges of the High Court will be recommended by the High Court Collegium. These are the facts we need to remember.